John Novak.
Can you hear me? Testing. Can you hear me?
Yes.
Okay, good.
I'm here, brother.
Good. One sec. Let's get the video going.
Okay, okay.
There we are.
Pepper, Uncle John is here. Pepper, Uncle John is here. Let's say hi. Come here. Come here. There might be a cat outside too, so that's possible.
All right.
Hey, come here. Come here. Come here. Come here. Come here. Okay. All right. Everybody want to see you, honey. Oh.
Hey, Pepper.
Is Pepper, wave hi to your fans. Okay, sweetheart. Whoa, boy. Well, that's off. All right, man. We got a good agenda today.
Let me do something real quick before we start.
Please
can
do.
I get the screen share?
Yeah, you start off. That's good.
Okay.
So, multiple is clicked. You should be on and ready.
Okay, let's find it.
Okay.
So I'm seeing this in the news today. It's going around making all the press. Young adult cannabis consumers nearly twice as likely to suffer from heart attack, research shows.
Really?
Now, in here, they're talking about how they did a study. Let's see, over 33,000 adults ages 18 to 44 included in the U.S. Centers for Disease Control and Prevention surveys in 2017 and 2018.
Okay.
Of the 17% of adults reported using cannabis within the previous month, 1.3% later had a heart attack, while only 0.8% of non-cannabis users reported the same. Now, I don't know about you, but those numbers, don't those fall, within the margin of error?
In the range of human existence?
0.8 versus 1.3. There's not a lot of difference there, but
they could say, it's 35% more. I guess that whatever percentage it is. It's like, but what other variables are there? It's ridiculous.
Yep. So can create a irregular heart rate.
Who is putting this out? CNN Health, but by whom?
World Health Organization.
Oh,
and the U.S. Centers for Disease Control and Prevention.
And the CDC. See, and they wonder why people don't trust them with the vaccines.
That's right. And here's the old trope that they're trotting out. Well, modern cannabis is extremely potent. It's not your grandfather's marijuana. It's like, well, actually it is, but the difference is we know how to grow cannabis today. We're much more trained. We're much better at it. Whereas before you got a lot of dirt weed but all those really good strains they've been around for a long time.
That's right.
A lot of the real potent indicas were used for hashish, which was smuggled over here to the United States. So I don't know. The whole thing just seems like reefer madness to me. To be honest with you, do you know anybody who's ever had a heart attack smoking pot?
They might have, but they were probably also doing a lot of rails and no, whatever they were doing.
Really. So in that comorbidity group, huh?
Yeah, the comorbidity group. That's exactly right.
So that's the main thing today. Like I said, I'm seeing it all over the news, CNN, Fox, USA Today, everywhere.
Yeah. Wow. But of course. All right, man. I'm going to fire up in a second here. And I'll drag up something real quick now. Share screen. I go, okay, desktop 1. Oh, okay, I'm there. All right, so I'm going to start with the Durkan bit, I think, right? Okay, so all right, so I'm such an idiot with this. Okay, so let's start with the Durkan one. All right, you can see the screen, right?
Yep.
Okay, cool. So this one here, we're gonna start with Jenny, and this is the employees who blew the whistle on Seattle mayor's missing text, filed a lawsuit against the city, right? Yep. Now, 1 second. 1 second. Okay, so for those of you who don't know, there are a couple parallels going on here. Obviously, Jenny Durkan, I'm not going to rehash, I said, the whole thing with Brian Corbray and how Jenny Durkan ignored our request for a meeting. And I'm waiting on information as to all of her communications with the equity task force of the city to see, how involved is she in that, right? So, to those of you, a quick rehash is that, yes, I asked her for a meeting along with Brian Corbray, the gentleman who she shut down when there were a couple of different federal memos saying, hey, don't do that. There was one already in existence, which I forget the name of it, but it was in regard to medical that was in existence before she shut him down. And then the Cole memo came out the year after. So anyway, bottom line is that they're dodging us on the information. But meanwhile, our largest newspaper, who still doesn't want to talk to us, has the Seattle Times. They have covered a couple of cases involving Jenny Durkan and her information requests, most notably their own. And now there's another one with some folks that I wrote them today. I wrote one of the plaintiffs and I said, look, share this with your lawyers. And I put out my history about what I've done in my, probably 8 public information requests, and I've lost one. And there was litigation on like half of those. So I put that out there, and I put a lot of my whistleblower stuff out there. And I said, hey, I'm here for you as a resource, and you should be here for me. Let's see what happens with that. Whatever they do, I'm still using their information in our lawsuit because it's all relevant. In the liquor cannabis lawsuit that we're in, as you know, I asked for text messages today because I bet you that none of these agencies are really monitoring their text messages as they should be or preserving them.
No.
And it's especially pathetic for Jenny because she was a federal prosecutor. And I can tell you back when, my goodness, I've litigated a lot of federal cases, some of which I can't talk about because of settlement. If you run my name, you'll see them. But there were so many times when I've known for years and years and years, any federal prosecutor knows, to be very assiduous about maintaining all kinds of electronic evidence. And so for that thing that happened with her, the missing text messages, and now the other employees are saying that they were constructively discharged because of abuse from her. Like I say, I wasn't there, but I called the reporter today. I called one of them and I said, when do I get 15 minutes with you, dude? Explain my lawsuit on this. And so anyway, before I leave on from Jenny, there's the story, and I just happened to see it on an actual newspaper, on an old school newspaper like that existed when I used to write for a daily, right? They kind of open up like this here, actually this is the newspaper. It's a different section, the other one's somewhere, but and it was there is Jenny.
So you were able to get a hold of some of the litigants?
One of them I got a hold of, forget her name. If I look in the messages, Stacy Irwin. Yep.
Oh, okay.
Yep. I wrote her, and I'll show you what I told her. Right. I have nothing to hide, man. So I started off back here with her, and I showed her, of course, the litigation that's going on with a lot of the documents, the motion to compel that's pending and all that. So I showed her that. And then after that, I showed her where I was a whistleblower against American Tower Corporation. I wrote the letter on behalf of my trainees, and there was like $290,000 in overtime back wages that were paid. Okay, did that. So there was that piece. Sent her that. And also, I sent her after that mayoral commendation, that was going on at the same time, like at 07. All right. So that was very intense too. The mayor was a really cool person, a Republican, by the way, against a Republican. That's one of the reasons he did that. It involves Lico Kenny's case, and also involves this case where I helped fix the school board that was trying to keep people from right of free speech. And that's an alderman with me, a white Republican alderman with me. Okay. And what happened when we did that? Well, let's find out what happened, guys. The city attorney agreed with us. Fancy that.
Imagine that.
Imagine that. Like, I might know what I'm talking about. It's kind of cray, isn't it? So there was that. And then I got one more too. I threw up the scribed one, and I said, oh, lest I forget, I've already sued Seattle under public information and settled. You know what I'm saying? You know, on the mortgages. So
Yeah.
it's like, it's so ridiculous. That's enough of Jenny. Let's move on to the next, shall we? All right. Good Lord. Good Lordy, Lordy, Lordy. All right. Close that out. Close that out. Cool, cool, cool. And during all this pepper, I managed to go to the beach, though. That was cool.
Hey,
Yeah, hey, man. That's right. It's like a field trip today. And, you know, it was cool.
what river is that?
The Snoqualmie. I mean,
Oh, okay.
Snoqualmie. No, still Snoqualmie. The Stilly, man.
Okay.
Yeah, right by the Stilly. I might have had a beer under the bridge. Anyway.
Ginger beer, right?
Yeah, right. A ginger beer. I drank it gingerly. Yes. Sat in the sun with pepper. All right. So there's that piece. And then the other piece I was going to talk about is final submissions. Yes, final submissions in our case. I already kind of talked about the emails in both cases, so we're done with that. And I'm going to close this out really quickly because my buddy cooked some pulled pork the other day. I'm about to eat it. I'm about to eat the leftovers. And I did salmon for those guys the 2 nights ago, but they did pulled pork the night before. And this is the leftovers that are just ready to go. So I'm about done with this. Okay, here is the third and final post Second Amendment complaint. Further notice of arbitrary and capricious misconduct. I wrote it on Labor Day. This is the Labor Day application of Robinson, a case locally, Hayes, and Tri-County, a landfill versus Brule County in South Dakota. So the first 2 cases, guys, are right. They involve Seattle. They're right smack here. The other one is South Dakota. That's 8th Circuit Court of Appeals, federal. But it's all germane to what we're talking about, and I'll run you through it real quick. Again, trying to prove yet again the issue of standing and that there is a reason for federal jurisdiction. And this is just one of the reasons, guys, really. But on the facts and law, on the arbitrary and capricious side, that's the underlying theme of the case. I had cited these cases a long time ago, and they never really responded to these. All right, no. You can see them there. They never really did. So I did. I expanded on them in this final memorandum of law. And I went into Robinson. A municipality may be subject to suit under Section 1983 when that municipality acts through an ordinance. I mean, I'm not going to bore you guys with the details. If you want to know, then read it. But don't question us because we know what we're doing. Yeah. And who taught me that? This guy, Ted Mearns. This guy. Like, he was a UVA professor. The UVA was ranked above Case Western. All right. UVA was like top 12 or so, top 10. And his wife was the mayor of Shaker Heights. I worked for him. I clerked for him in law school. I got an A in his class. What can I say? I mean, this guy, this is what I did, man. And so these people crack me up trying to discredit my black ass. It's unbelievable. So, all right. So I'm just dying here, man. So, all right, we come back to 1983 liability, right? And so that's Robinson. And bottom line was that we reject the city's contention that this court held as a matter of law that Seattle's enforcement of the HPO could not give rise to civil rights action. As Robinson's point out, this court simply didn't consider that issue on appeal. But on review, they're saying, well, it sure could. Boom. All right, this issue was not presented. So we're going back. Boom, remand. Next case, Hayes. By the way, I met Isaac Hayes once, man. It was his voice and I'm in his elevator with him and Evander Holyfield and my parents and my sister. And there was somebody else famous in the elevator. It was crazy, man. Nice. The Rhythm and Blues Foundation annual awards like 12, 15 years ago. I don't know. But it was crazy. Bootsy was there. Anyway.
Oh, yeah.
Dude, Bootsy was there.
Wasn't he a drummer or a bass player? I can't remember.
Bass. Bootsy was there. And George Clinton was with them. And so was Maceo. Dude, they were all there, except for James wasn't there at the event. And we all sat at the big table. It was crazy. I have like one picture from that show. I don't know what I did with them, but anyway, I digress. Back to Hayes. Court of Appeals. Hayes moved for summary judgment. This is all like state ordinances, guys. They're saying that the question of law, revolves around a state issue of law. Well, of course it does, but so does zoning. For example, there's zoning cases. Of course, it centers on a state law at bottom, but if you arbitrarily or capriciously apply that law, then you're subject to 1983. That's what all these cases clearly say, dude. Yeah. Oh, I know, I don't mean, So this is the Court of Appeals finding. I didn't write this. This is the court writing this. Was it invidious or irrational or arbitrary or capricious? We held that the county's denial of a conditional use permit was a violation of substantive due process. What? That's our argument. God damn it. Oh, there it is. Still slipped out. But yeah, so I mean, I don't have to go any further. That's what they keep going through that right there. And then this is a good paragraph here before I wind up. In Lutheran daycare, however, we said a violation of substantive due process can occur either that's in the conjunctive, right? Oh no, actually that's in the disjunctive. That's right. That means either. The conjunctive means you have to have both. All right. Right. Yeah. So either from invidious or irrational action or from arbitrary or capricious action. We held that because the trial court had already found the county's actions in the writ proceeding arbitrary and capricious, the appellant, quote, has established as a matter of law and fact, both, okay, that the county violated substantive due process when it denied the conditional use permit. I'm like blue in the face saying this. Yeah. On that. So, wow. And then we just, oh, wait, there's one more. Okay, before I finish up. Whoa. I mean, this is crazy, man. When I look at the wealth, the work that I've done, that you've done, that we've done. So here's landfill. That case, they denied a landfill. This is the 8th Circuit. They talk about the different types of due process, substantive and procedural. And here, rather, substantive due process prevents governmental power from being used for the purposes of oppression or abuse of government power that shocks the conscience or action that's legally irrational and that is not sufficiently key to any legitimate state interest. So that's all in the same, ballpark there, the same branches of law. Yep. Yeah, so good Lord. So here's the final close on it. The finding of liability by the trial court solely on its arbitrary capricious finding was wrong. But then it says allow this liability to determination to stand would elevate every violation of state law. It's a federal constitutional tort, right? But they remanded it back there. But the point was that there's dissension within that case about what's proper. And that's why I threw it in there because
got some chicken yakisoba.
Hey, Adam C. Who is it?
Chicken, shrimp, beef.
Okay, bye-bye. It's a fucking asshole. Yep. Those are the guys. I have a guy from Boston who follows me around whenever I'm hot on a case. He's a piece of shit cracker. He's called me all kinds of derogatory names. He's a fucking piece of shit racist. I wrote the FBI and asked them to track him. They didn't do anything, okay, because they treat me like a nigger too. And that's the fact, all right? So all of this is on Zoom now. And there it is. So Adam C is a pseudonym for whatever his name is. And Adam C, for you, I'm gonna smoke some of the best pot I've ever had. This orange wedding cake. Ooh. And I rode a couple different motorcycles today, Adam C. I know you're a huge motorcycle guy. You're the best rider in the world, I think. That's what I've heard. So this is in your honor, dude. Is it? Yeah, sure. I love you, man.
Orange wedding cake. I'll have to look for that one.
And this is the original strain, to the extent that any of these new strains are original, but it's very nice.
Right.
It's very nice, John. I think you'd like it. Yeah, so I shot that off just like point by point, just for the record. So we have it on Zoom. And that one's definitely going to go up. Like, I don't post all these to YouTube, but this one has to go up because it's black letter law.
Yeah.
Yeah. And meanwhile, I get this Adam C guy chasing me around. He goes on to say, you were never a lawyer. You've never won jury trials. You've never done this and that. I mean, you talk about a guy that's like set up. He's a pawn, probably on his knees for somebody in government. He probably did some time. He's probably an informant, a weasel, a scumbag. And then, I'm so irrelevant that he takes time to write in and call in, right?
Yeah.
It's pretty wild, man. You got anything else, John?
No, that's it. I did see, I saw a little bit of an article from Cannabis Observer. It sounds like the Department of Health is going to start taking medical marijuana a little more seriously. It looks like they've been tasked to start looking into the medicinal values and what different products that patients are using.
Okay.
Which is quite a step from where they started. Basically, they didn't want anything to do with labeling it medical. They didn't want to recommend it or anything of the sort. The only thing that they would do was subject it to a higher level of testing. So it was like laboratory grade, and that was what they were calling medical. But it sounds now like they might be
Changing
starting to look into the medical values.
Okay.
So I'll do a little more research and give you an update on that.
Sure. That sounds great, man. Sounds great.
Hey, gentlemen, if I may add, you guys know Israel.
Actually, you may not add. Get the fuck out. This is for you, asshole. This is for you. You can't add anything. Yeah. Make your own chat board if you want to. Nobody cares about you. All right. I have people from Hollywood calling me about shit. All right. So, yeah. So, bye-bye. You put the bud to the bye and the bye-bye. Bye-bye. All right, John.
All right. Sounds good, brother. We'll see you soon.
We'll wait and see what the court does.
Yeah, exactly. That's about all we can do at this point.
We've done plenty. Yeah. And thanks to all of you who helped us do it too. It's not like it's just us or just me or him. That's all you guys, and we appreciate it.
Right on.
Right on.
Ciao, guys. Later, guys. Peace.
Yes.